It is my pleasure and honor, and indeed privilege, to introduce our keynote speaker, the Honourable Chief Justice Leonard S. Marchand, Chief Justice of BC, Chief Justice of the Court of Appeal for BC, and Chief Justice of the Court of Appeal of the Yukon. And just so you know, that's another justice chuckling over there. The Honourable Leonard Marchand is the Chief Justice of BC and all of those places, and he was appointed Chief Justice on December 7th, 2023. My law firm was on retreat in Tofino. We stopped our meeting so we could watch it because it was televised. And Marion Buller is now on our team. So when he gave her the shout out, our room erupted because we had a lawyer that was getting shouted out by the Chief Justice. It was a really memorable day. Chief Justice Marchand was appointed to the Provincial Court of BC on September 5th, 2013. As a provincial court judge, Chief Justice Marchand had the privilege of presiding in Chinookwanton Court in Kamloops, where, with the input from elders, healing plans are developed for Indigenous offenders. Chief Justice Marchand was appointed to the Supreme Court of BC on National Indigenous Peoples Day, June 21st, 2017. He was appointed to the Courts of Appeal for BC and the Yukon on March 4th, 2021. Prior to becoming a judge, Chief Justice articled and practiced at Fulton and Company LLP in Kamloops from 1994 to 2013. His practice focused on the liability of public authorities, and he appeared before all levels of court in BC and before many administrative tribunals. Chief Justice Marchand dedicated a substantial portion of his career as a lawyer to pursuing reconciliation between Indigenous and non-Indigenous peoples, including by advancing civil claims on behalf of residential school survivors. In 2005, he helped negotiate and was signatory to the Indian Residential Schools Settlement Agreement, which, at the time, was the largest class action settlement in Canadian history. And we thank you for that hard but good work. He then served on the Oversight Committee of the Independent Assessment Process and the Selection Committee for the Truth and Reconciliation Commission. Chief Justice Marchand is Syilx and a member of the Okanagan Indian Band. He grew up in both Kamloops and Ottawa. After completing a Bachelor of Applied Science in Chemical Engineering, I mean, that deserves a round of applause in itself, at UBC in 1986, before some of you were born, I think. He worked in the oil industry for several years. He then attended law school at the University of Victoria, graduating in 1994. He was called to the bar in 1995 and to the bars of the Yukon and the Northwest Territories in 2006. Chief Justice Marchand divides his time between Kamloops and Vancouver with his wife, Lori. Together, their family also includes 3 grown children, their children's partners, and 2 much-loved grandchildren. Please join me in welcoming Chief Justice Marchand to the podium.
Hi, Ishka. I was a shy kid, and if you'd asked me about being a lawyer, I would have asked you if you're out of your mind. So, being good in chemistry, math, and physics, I became a chemical engineer before I realized that was not my calling in life, and maybe there was something for me here in the law. Anyway, hi, Ishka, for that nice introduction. Lim lim to everyone. Thank you for the opportunity to be here together with you today. I accepted this invitation for this keynote without a set topic, but eventually settled on topics that have been on my mind in one way or another for a long time. pluralism, and inclusion. I want to start with a story about my father. Like me, and probably many of you, my dad often felt that he inhabited more than one world. One of his worlds was made up of his Silks family, people, culture, language, and traditions, and the other was what I'll call his Canadian world that included the education that he received in the 6 Mile Creek Federal Indian Day School in our community, at the Kamloops Indian Residential School, and eventually in the public school system, along with the impact of political, economic, legal, and other forces on the land, his family, his community, and his people. My dad was culturally grounded. Insilkshan was his first language. He grew up on the land. His family had some cattle, horses, and chickens. They grew hay. They had a lovely garden. They also hunted, fished, and gathered edible, though not the kind you find at the corner cannabis store, but berries, roots, and other things. Against all the odds, my dad completed bachelor's and master's degrees in agriculture at a time when obtaining that type of higher education was quite rare amongst Indigenous people in Canada. And he became a range management scientist. He was unique, at least at that time, as a person who knew the Insilkshan scientific and common names of all the flora and fauna of the southern interior of BC. So he was as comfortable calling a grizzly bear Kilauna, which is Insilkshan, as he was calling a yellow-bellied marmot Marmota flaviventris, which is Latin. He knew what was good to eat and what leaves to chew up to make a salve if you got stung by a bee, but also which plants were haploid and which were diploid, and how to optimize the productivity of grasslands. He had a great array of bird and animal calls and taught his grandchildren all about the natural world. He was what we would call today an ecologist, which wasn't very different from him just being himself as a Silks person. The influence of my dad on my children came home to me when my oldest son, Miles, was about 5. And the two of us were sent into the gully in behind my parents' home in Kamloops to get some pine cones, to make a centerpiece for a Thanksgiving dinner that we were having. And I pointed out what I thought was a really nice one to Miles. I asked him, "What about that one?" And he said, "Which one?" And I repeated, that one, pointing more closely. And he said, "Which one? I don't see it." And so I picked it up and I said, "This one." And he looked at me with 5-year-old disdain and he said, "Dad, that's not a pine cone, that's a fir cone." And I can assure you that he did not learn that from me, and he did not learn that at school. He learned that from, his granddad. And like his granddad, Miles really took to science, and now he's just about to finish up his 6-year residency in cardiology, and he's looking forward to working in the area of Indigenous heart health. And it's pretty great. And my dad played an important role in his trajectory. My dad was also active politically as he tried to right injustice. One of the greatest hurts that he had in his life was not being able to vote in his own country. So he fought to change that and many other inequities. In 1965 or so, my dad was at a meeting with others involved in the North American Indian Brotherhood. The late, great George Emanuel said they needed someone in Ottawa, someone who was grounded in Indigenous ways but educated in Canadian ones. My dad was the obvious choice and soon became the first Indian to work as a special assistant to the Minister, ironically, of Citizenship, who was then responsible for the Department of Indian Affairs. And that job in Ottawa led to a bunch of other political firsts as my dad did his best to bridge two worlds and bring them together in a good way. I'd like to think he never approached the two spheres of his life in a hierarchical way. Rather, he saw how one could complement and enhance his understanding of and life in the other, and vice versa. And I'll say a bit more about this a little later. So let me turn now more directly to the topics being discussed at this conference: Indigenous legal orders, language, culture, and transforming legal institutions. And I don't profess to be an expert in any of these topics, but they're all of deep interest to me. It's been impressive hearing today from Robert and Sarah and others on other occasions about the work that's being done to preserve and promote Indigenous languages, laws, traditions, and cultures. All of this work is playing an important role in advancing another subject that's of deep interest to me, and that's reconciliation. The TRC defined reconciliation as an ongoing process of establishing and maintaining respectful relationships. They recognized that a critical part of the process had to involve revitalizing Indigenous law and legal traditions. They saw how important it was for all Canadians to understand how traditional First Nations, Inuit, and Métis approaches to resolving conflict, repairing harm, and restoring relationships could inform the reconciliation process. The TRC saw the value in both, one, making space for the implementation of Indigenous legal orders, and two, reforming Canadian legal orders by taking account of Indigenous ones. So the first of these approaches we recognize and label as pluralism, and the second as inclusion. And I'm going to speak about both. I'll start with pluralism. As my kids might say, legal pluralism is a thing. It's a constitutional thing, but it's a thing nonetheless. The BC Law Institute provides a workable definition of legal pluralism. It says it's the operation of two or more legal orders within the same geographical jurisdiction or social space. Various courts, including the Supreme Court of Canada, have already recognized legal pluralism as a fact in Canada. It exists, and it's not something that's foreign or new. The best and most obvious example of legal pluralism is the coexistence of the common law and civil law in Canada. We also see examples of legal pluralism in the context of Indigenous legal orders all around us. Some Indigenous laws flow from powers delegated to band councils via Section 9124 of the Constitution Act 1867 and the Indian Act. Some are recognized under Section 35 of the Constitution Act 1982, and some stand entirely on their own. To date, the Supreme Court of Canada has not discussed legal pluralism extensively, but the court has long acknowledged its existence. For example, in the family law context, where each province defines the effect of common law relationships differently, which the court has said is a mark of Canadian legal pluralism. One notable piece of recent Supreme Court of Canada commentary can be found in Dixon and Vuntut Gwich'in First Nation, where Justices Martin and O'Bonsawin stated, "The Constitution Act 1982, which includes the Charter, is a pluralist document that's capable of incorporating and reflecting Indigenous and non-Indigenous perspectives alike. The Living Tree interpretive doctrine ensures that these perspectives can be built upon in the future." Although the justices were in dissent, the recognition of pluralism in the specific context of Indigenous laws falls within a long line of Supreme Court of Canada cases. For example, although accompanied by some limiting words, former Chief Justice McLaughlin confirmed in the 2001 case of Mitchell and Canada that Indigenous laws are presumed to have survived sovereignty and to continue as part of the law of Canada. The jurisprudence and commentary on the emergence, or better, what I would call the reemergence and continuation of Indigenous legal orders are growing. Judges are relying on scholars like John Borrows and many others to apply, and Sarah Morales right over here, I got excited there, Sarah. And it is exciting to be in the room with people like Sarah and people like Stephen Point. I did give a shout out to Marion during my welcoming ceremony. I also gave a shout out to the other fella who's sitting at that table, who's another one of my heroes, Stephen Point. All right. These legal scholars are helping us to learn how to apply an evolving understanding of what law is and how different legal orders interact and coexist. In a judgment now 10 years old, Justice Mandaman of the Federal Court provided a useful overview of the existence of Indigenous legal orders as recognized through a legal pluralist lens, starting with Connolly and Woolrich, which was decided in Canada's birth year, 1867. In that case, the Quebec Superior Court held that a Cree marriage conducted in accordance with Cree custom was legally valid, thus recognizing the coexistence of Indigenous law alongside and as part of Canadian law. Justice Mandamin went on to enumerate the various other common law, statutory law, and constitutional law contexts providing for the operation of more than one legal order in the same social and geographical space, which sounds consistent with that BC Law Institute definition that I shared with you about legal pluralism just a moment ago. He commented that an aspect of reconciliation is that when Canadian law recognizes Indigenous law, it may at times have the effect of altering or transforming Indigenous law so that it and Canadian law are aligned. This federal court jurisprudence has been built on by Justice Gramont, both in his decisions and in his commentary. In a case called Georgian Heiltsuk First Nation, Justice Gramont discussed the independent coexistence of Canadian Indigenous law while acknowledging, too, that there may be contact points between the two systems. He concluded in that case that the court did not have jurisdiction to review decisions made solely pursuant to Indigenous law. In Pastion and Deneta First Nation, Justice Gramont observes that First Nations law might blend Indigenous traditions with Western democratic ones, which are things that we heard about from the Morales, and that the court's role is to respect the manner in which various sources of law might be blended as a matter for each First Nation to decide. In his paper, Recognizing Indigenous Law, a Conceptual Framework, Justice Gramont develops these ideas further. For example, he talks about Indigenous peoples' right to define their laws based on internal deliberation. He observes that Indigenous law, like the common law and civil law, is continuously evolving and borrowing from other traditions. And most recently, Justice Gramont delivered a judgment earlier this week. I'm reading the law. I'm keeping current, like all of you. Where he spoke about the need for courts to show deference in the Indigenous law context. And he wrote that deference towards Indigenous decision makers reinforces self-determination, and that deference may be especially warranted where an Indigenous decision maker is applying unwritten Indigenous law. Now, while my focus has been on these jurisprudential developments, I note that, as an aside, that independently, the BC government has explicitly recognized the existence of legal pluralism. In its 2022 to 2027 action plan, it says there are multiple legal orders, including Indigenous laws and legal orders with distinct roles, responsibilities, and authorities. In a number of cases, pluralism is depicted only as achievable where, and I'm quoting here, people of all groups understand and tolerate each other. Now, I personally don't prefer the word tolerate. The word connotes to me a group that considers itself to be superior, putting up with a group that it considers to be inferior. And I've never thought that that's something that we should aspire to. I prefer an equality lens where difference is acknowledged, accepted, understood, accommodated, and maybe even celebrated. And I like to think of pluralism as a harmonious coexistence. And I think that links well with what Robert was saying earlier. The BC Law Institute has said that applying a legal pluralist analysis to coexisting legal orders can help with both understanding existing arrangements and building and maintaining respectful relationships between legal orders. And for me, the key words here are understanding and respect, which go hand in hand. For those who don't see Indigenous peoples as having real laws, there's much learning to do, and I believe that with learning, respect will be built. And I would say the same thing to anyone who says that the Canadian justice system has little value to offer as well. Professor Val Napoleon has offered some observations that to me go to the heart of reconciliation between legal orders. That what matters is learning to see the law of others as law in its own right, which may push the boundaries of our understanding of what law is. That's in order to make visible and intelligible the laws beyond our own perspectives. Canada and BC's adoption and implementation of UNDRIP's Declaration of the Rights for Indigenous People to Develop and Maintain Their Juridical Systems and Customs will not go far if we're unable to see the very existence of those systems and customs in the first place. Is delegation, recognition, acknowledgement, accommodation, emergence or reemergence of Indigenous laws and legal orders all we need? I say no, and this is where inclusion comes in. Speaking as the Chief Justice of apparently everything, it should be self-evident that I believe in and am invested in the integrity and value of the Canadian justice system. And this is not to say that I don't see the flaws in the existing system as it is and as it has historically been. On the contrary, I see the system's many strengths, but also its weaknesses. I also see the breadth and impact of, I also see the breadth of its impact on us all and its important role in preserving all that's good and improving all that's not good. And as much as we know Indigenous legal orders are not going anywhere, neither are Canadian ones. So we must and can do better to ensure that the Canadian justice system lives up to its promise. We must recognize that the way forward has to include making the Canadian system more inclusive and welcoming. It's no big secret, especially to the people in this room, that Indigenous people in Canada come into conflict with the law in negative ways in grossly disproportionate numbers. In particular, incarceration and child apprehension rates are astronomically higher for Indigenous people than for other people in Canada. Yet in other areas, Indigenous people come into contact with the law in disproportionately low numbers, in the sense that when faced with a legal issue, Indigenous people are less likely to turn to the justice system for help. The reasons for both of these phenomena are rooted in our colonial and post-colonial history of misguided notions of superiority and the twin, opposing, but equally harmful policies of assimilation and exclusion. And I pause to ask you, how did the colonial and post-colonial powers in Canada expect to assimilate Indigenous people when excluding them at the same time? Both policies were deeply flawed. Many Indigenous people in Canada see an adversarial justice system focused on correction and punishment that does not reflect their histories, cultures, customs, and values. Many have historically experienced a system that's unjust and unfair, where they do not feel respected or understood, and where they usually lose. And as a result, even though we've taken a number of very positive strides, Indigenous people are less likely to exercise their rights or participate as a plaintiff, complainant, witness, or juror. Like, why bother? For example, why would an Indigenous person think to turn to a human rights tribunal when it's normal to face discrimination? Why would an Indigenous person file a criminal complaint when they don't expect to be treated with respect? Why would an Indigenous witness attend court when they don't expect to be believed? And why would an Indigenous person show up to serve on a jury when they, their families, and their communities have not had good experiences in the justice system? The result is isolation, division, and conflict, which isn't in anyone's interest. Clearly, we have some heavy lifting to do to demonstrate that we have a justice system for everyone. But I'm optimistic that we can make real progress, and my optimism is not the rose-colored glasses kind of optimism. It's a realistic optimism based not only in my observations of the real progress being made to revitalize Indigenous legal orders, but also my experiences in the Canadian justice system. And here's an example to demonstrate what's possible. I began working for residential school survivors in the late 1990s, and at the time, standard civil litigation was the only real recourse available. Given how the Canadian justice system had so negatively affected Indigenous people in Canada for such a long time, my residential school clients were understandably very reluctant to go to court. Just going through examinations for discovery was pretty awful for them. Despite testifying with honesty, dignity, and integrity, they often felt disbelieved and disrespected. And I mean no offense to the Department of Justice Council, who were doing their best, but many of my clients were shredded by that experience. A lot of questions focused on causation issues, so my clients felt like Canada was trying to blame other traumas they experienced away from residential school for the difficulties they were experiencing in their lives. In other words, it felt like Canada was arguing that as Indigenous people in Canada, life was going to be pretty crummy for them regardless of their residential school experiences. And who could possibly feel good about the prospect of going to court expecting to be treated like that? And what about the forever relationship between Canada and Indigenous people? How is that relationship going to improve by Canada defending the indefensible in an adversarial setting? From the start, I thought we needed to find a better way. Fortunately, I was not alone. In time, to its credit, Canada invited me and other like-minded claimants' counsel to work on various committees looking for a more proportional, supportive, less adversarial, and frankly, less damaging way of resolving residential school claims. And I have to say that we did find a better way through the Indian Residential School Settlement Agreement and the adoption of the independent assessment process. The The IAP, as it was called, was absolutely informed by restorative justice principles. It was a supportive and non-adversarial process that awarded compensation to claimants who suffered specific types of sexual, physical, and emotional abuse at residential school. Was it perfect? Of course not. But it developed such credibility that over 30,000 of about 80,000 living former residential school students advanced claims. And the vast majority of the claims were validated by independent adjudicators. Although money was no substitute for what survivors experienced and lost, the validation, recognition, support, treatment, compensation, and apologies they received through the process made a big difference in many lives. If not for the non-adversarial and claimant-centered nature of the process, there's absolutely no way that 30,000 plus former students would have come forward, and there's absolutely no way that the Canadian justice system could have adequately addressed the thousands of claims that had been filed. Access to justice would have been severely undermined for everyone, with many survivors not seeking justice and many non-Indigenous parties being slowed down or prevented from accessing a justice system clogged with the complex claims of the survivors who had filed claims. Another example of what's possible is the launching of many Indigenous sentencing courts all across BC and, frankly, all across Canada. I absolutely loved serving as a frontline provincial court judge. The greatest highlight was sitting in the Kinakwutiin Indigenous Sentencing Court in Kamloops, and Kinakwutiin means the place where help is given in Shwetmuksheen, and that's what we did. As you heard, with the input of elders and others, we developed healing plans to help Indigenous offenders turn their lives around for the benefit of themselves, their families, their communities, and really all of us, including victims. Let me bring home the benefits of Indigenous sentencing courts by telling you about a particularly memorable case that I had. An elder from a local reserve pled guilty to one count of aggravated assault. During an evening of drinking on his home, or at his home on the on the res, the elder stabbed a drinking buddy of his 6 times. The wounds required numerous sutures, but fortunately the friend recovered without complication. The usual range of sentence for an aggravated assault is 16 months to 6 years, with unprovoked attacks involving a weapon, like this one, typically landing at the higher end of the range. The elder had a pretty extensive criminal record, and the Crown proceeded by indictment. In the not-so-very old days, the elder could have expected to be locked up for 4, 5, or maybe 6 years. But a Gladue report informed me about many traumas the elder and the elder's family had endured, including as a result of attending residential school. The complainant attended court to say that he'd forgiven his friend and did not want him to be incarcerated. The elder's counselor attended court and shared that he'd successfully completed violence prevention and anger management programs. The chief of the community attended court and informed me that when sober, the elder was a valued community member with important traditional knowledge. The community wanted the elder to be accountable to it and proposed that he do so by working for the community and sharing his traditional knowledge with youth. And the community did not want to lose the elder through a custodial sentence and was prepared to provide him with housing, income support, and access to traditional healing opportunities as well as counseling. The court elders recommended that the elder attend the Sweat Lodge and complete residential trauma and substance abuse programs designed specifically for residential school survivors. And after considering all of that information and input from others, I concluded that a right approach was to emphasize rehabilitation and restoration. At the time, a conditional sentence order was not available, so I imposed a 3-year period of probation with 6 months of house arrest, followed by 12 months of curfew, 100 hours of community work service, abstention, and leave on request terms. And in my view, those terms would adequately address denunciation, deterrence, and protection of the public. I attached a healing plan to the probation order, including terms that the offender participate in a community restorative justice program, attend a peacemaking circle, attend counseling, make best efforts to attend an identified trauma and substance abuse program for residential school survivors, participate in the Sweat Lodge, and work with community youth. And one of the great things about these Indigenous sentencing courts is the process of reviewing how the offenders are doing. So they're coming back to court and they're held accountable, not just to the judge. Well, the people who are really holding them to account are their respected elders. So subsequent reviews in court indicated that the elder was doing well and was complying with all the conditions, including the abstention term. He'd written a formal letter of apology to the complainant, his friend. With the chief's help, he'd enrolled in the Choices program and was on a waiting list to attend the trauma program at Southern Laleham. He had worked with youth at a summer camp. He would be fulfilling his community work service hours through the construction of corrals for the benefit of the community. He was happy to have the support of Chief and Council, and Chief and Council were understandably very proud of him. So this was obviously a great outcome for the elder and the community, and the taxpayers didn't have to foot the cost of housing the elder for up to 2 or 3 or 5 years at great expense and for no apparent benefit. So through these experiences, I've learned that the Canadian justice system can be improved if we listen, learn, are open-minded to including Indigenous perspectives, and take action. Even if, or maybe especially when, that takes some of us out of our comfort zones. Courts are learning gradually, and I'm now aware of a number of instances across Canada where Indigenous perspectives and practices have been incorporated into proceedings. So for example, in my own court, Indigenous parties were provided an opportunity for elders to attend and perform a cleansing ceremony in the courtroom where an appeal hearing took place. Courts in a variety of other jurisdictions have incorporated Indigenous ceremonies and symbols like smudging, blanketing, drumming, and eagle feathers into their proceedings. Given that Indigenous incarceration rates remain stubbornly, even grotesquely high, some may argue that inclusion has failed. But I don't think we can say that, because we don't know where the justice system would be now if we hadn't made the efforts that we have. My educated guess is that things would be worse, or maybe a lot worse. We've taken some important strides, but there's still a long way to go. So let me take a moment to relate things back to my opening comments about my dear old dad. As a sitting judge, it's not my place to say what the future role of Indigenous laws will be in our society. I have personal views, of course, including that judges have a duty to learn more about what's heading our way. But like my dad and his approach to the natural world, I don't see the future of the law as a matter of hierarchy between two or more competing systems. As things develop, and without prejudging anything, I expect to see that core values like fairness, informed decision-making, and transparency will transcend and be reflected in both systems. That the systems will complement one another so that justice is done in a meaningful way for all parties involved. That the Canadian justice system will learn from and improve because of the development and implementation of Indigenous legal orders, and that Indigenous legal orders will be able to borrow from or depend on the Canadian justice system, again, as we've heard about, as they evolve, get stronger, and become more established. It's not lost on me that the BC First Nations Justice Council has structured its work along 2 tracks. Track 1 is about reforming the Canadian justice system to be safer and more responsive to Indigenous peoples. And track 2 is about restoring Indigenous justice systems, legal traditions, and structures. So to me, track 1 is what I've referred to as inclusion, while track 2 is about pluralism. We need both. So let's continue to encourage all actors within the Canadian justice system to learn more about their local Indigenous communities, their histories, their ways, their challenges, and their resources. How else can we meaningfully understand, accommodate, and meet the needs of the Indigenous people who are interacting with the justice system? Let's work hard to build mutually respectful relationships with lots of space for Indigenous people, communities, customs, traditions, and laws. How else can we demonstrate that we can deliver justice for everyone? Let's take responsibility for our own learning and show humility by really listening to the perspective and wishes of Indigenous people and communities. Let's not make harmful assumptions or think we know best. And let's not allow ourselves to be passive bystanders to inequity, and instead take action aimed at achieving a harmonious coexistence. This call was raised by one of my predecessors, mentioned earlier, former Chief Justice Lance Finch, in A Duty to Learn, where he stated that there is a legal obligation to take account of, his word, Aboriginal perspective, and that the courts must be capable of understanding the nature of Aboriginal rights and interests. And this call was reinforced by and advanced further by my immediate predecessor, former Chief Justice Robert Bowman, in A Duty to Act, where he stated that our assumptions about law and equity must be questioned, we must unlearn and defer, and we must hold space for hard conversations and be willing to be wrong. The image of braiding has been invoked by many to illustrate the strengthening of the individual strands of law through their joining together in mutual respect, each preserving their unique identity and purpose while complementing the whole. This conference and similar opportunities to deepen our understanding of Indigenous legal orders and their legal and theoretical underpinnings give us the technique or methodology for braiding that's essential to our path towards reconciliation. So I'll just conclude by thanking the organizers, the presenters and participants for all of your important work. And I want to thank you again, Lumlumt, for inviting me to be a small part of the program today. Thank you so much.